Oyez, oyez, oyez. All persons having business before the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-3036. United States of America versus Rowena Joyce Scott, appellants. Mr. Berman for the appellant, Mr. Hansberg for the appellate.
Good morning, counsel. Mr. Berman, please proceed when you're ready.
Good morning, Your Honor, and may it please the court. I want to devote my time this morning to a pure sufficiency claim, namely the government's failure to prove beyond a reasonable doubt that the defendant, Rowena Joyce Scott, caused interstate wire communications to execute the charge scheme to defraud. The wire fraud charges in this case, counts 1 through 3, alleged that on 3 occasions in early 2014, Ms. Scott withdrew cash at a Wells Fargo branch here in DC. And that, quote, in processing the transactions, computers at the branch connected electronically with Wells Fargo computers and servers located outside of DC. The government attempted to prove a connection to a server in Minnesota, but it did not do so. Interestingly, the government chose not to present a witness from Wells Fargo, and the evidence that it did present was so thin that it didn't allow the jury to even draw a permissible inference that Ms. Scott's withdrawals triggered interstate communications. The jury could only engage in what this court has called, in a variety of cases on this subject, mere speculation or surmise and conjecture. Let's look at the evidence they did present. At Appendix 2581 to 2590, they presented portions of bank statements and withdrawal slips, paper withdrawal slips, that Ms. Scott signed on 3 occasions.
Those a lot of these withdrawal slips were for money taken off the books, off the ledger, and then later on explained. Is that correct?
Yes, Your Honor. And we're not challenging the government's proof on the first, that the government proved the fraud scheme. I'm limiting my argument to the second part, that whether or not the government proved that she caused execution of the fraud scheme via interstate wire communications. And those paper withdrawal slips do not on their face show or help prove in any way an interstate wire communication. The second thing the government offered was testimony from the IRS case agent, who obviously had no personal knowledge of the Wells Fargo system. And I would say here that the AUSA asked the wrong questions and as a result got inadequate answers. The agent testified she had investigated the Wells Fargo transactions and that she'd made determinations, but she didn't say what the investigation proved or what the determination was. At Appendix 1143, did you investigate whether any of the bank transactions that we've been discussing with the Park Southern accounts involved the use of electronic communication? She says yes. Okay, so we've established that she investigated. Did you investigate whether any of those electronic communications went across state lines? Answer, yes. Again, all that establishes is that she investigated. Appendix 1148.
Can I just ask I'm
yes.
trying to just understand exactly which part of the elements of proof you're focusing on here. So suppose in that exchange, the witness was directly asked, okay, then you investigated, you said you did, and did you find? And then depending on which question, take the second one. Well, can you read back the second one you just?
Sure. Second was, did you investigate whether any of those electronic communications went across state lines?
Yes. Okay. Now suppose the interrogator, the lawyer, went a step further and said, okay, and then did you find that they did? And then she said yes. Then what is this? If that were true, and I know it isn't, but if that were true, is this argument you're making foreclosed?
I think the government would be on much stronger footing if the answer had been that. And with that, let me proceed to the next question, because at Appendix 748, the prosecutor asked Special Agent Reese, did you determine whether, not that, whether this bank branch in Washington, D.C. communicated with a computer anywhere else in the country to process these withdrawals? The answer is yes. I submit that simply established that she made a determination, but not what the determination was.
But isn't it also in the record that there was a business record from Wells Fargo showing the DC branch, that the server was located in Shoreview, Michigan, and that the settlement method was electronic? And I'm looking at JA 3605, which is the exhibit introduced through testimony at JA 1150. It seems like that would be sufficient together with the yes answer about the determination to support the jury's finding that the withdrawals involve interstate
Well,
communication.
so what I'd say about that record is two things, Your Honor. First is that I think the court has to disregard the first 3 pages of that exhibit because that's merely a business record certification under Rule 902.11. And so, for example, the part of that exhibit in which the government quotes from a letter from the Wells Fargo paralegal is not substantive evidence to prove the wiring. If it were, then we'd have a confrontation clause problem under Melendez-Diaz. But turning to that particular page, Your Honor, what we have is 14 columns here, right? Ranging from type of item or transaction to Wells Fargo account number all the way across to the last column, which says settlement, monetary process, and location. And the problem was that there was nobody, I think that the record on its face, I would submit, is not self-explanatory. The agent didn't really do any explaining. The agent simply said, this column says this column says that, this column says the other. And I would submit that to draw a conclusion from this page that the withdrawal in DC caused a communication to Minnesota is surmise and speculation rather than an appropriate inference. Absent testimony, absent some explanation. Again, this record I would submit is not self-explanatory. And in that regard, I think it's worth noting that the last heading all the way to the right, where the heading says settlement, monetary process, and location column. And it indicates right in the heading that Wells Fargo's usual process is to provide specific information about an interstate wiring. For example, that it's from Texas to Minneapolis, or from Minneapolis to North Carolina. And yet this column here doesn't say any such thing. It simply says settled internally via customer's demand deposit account. I would submit that answer, and I have larger copies of this exhibit of this page if the court would like them.
This is the one, which page of the?
3605.
3605, yeah.
And I can give the clerk larger copies if the court would like them afterwards. But what I would submit is that this column all the way to the right, where it simply says settled internally via customer's demand deposit account, that really doesn't prove anything about whether or not this withdrawal caused a communication between DC and
Now, the column next to that, I mean, using my magnifying glass to read it, the column next to that says electronic on it, right?
It does say electronic, but to me, that doesn't add up to establishing that that this transaction caused an electronic communication from DC to Minneapolis.
But the only question is,
to
for your purpose, this is part of a sufficiency argument, right? So
yes,
what we're looking at is whether any rational jury could have taken the accumulation of this exhibit and the testimony that didn't get, I take your point that it didn't get all the way to be brought home as definitively as it might have been.
Mhm.
But the question is whether whatever implication they might have drawn from the exchange that was made, plus the documentary evidence, could lead a rational jury to conclude that the wire communication.
Well, Your Honor, we've quoted from the Bethea case and the Carter cases, and there's a dozen others going back to the 1940s and as recently as a couple of years ago, in which the court draws a line between mere speculation and surmise and conjecture on one side and appropriate inference on the other side. We would submit that all this evidence adds up only to mere speculation and conjecture. And with that, I'll reserve the remainder of my time.
Thank
Well,
you.
just a quick question. Are you giving up on the statute?
We'll give you a little bit of rebuttal time.
Yes, Your Honor.
But are you giving up on the statute of limitations issue?
Well, we'll rest on what's in our reply brief.
Okay.
Thank you, Mr. Berman. Mr. Hansford.
Good morning, and may it please the court. Eric Hansford for the United States. Sufficient evidence supports the defendant's various convictions in this case, and the district court correctly denied the suppression motions. I'll start following counsel's lead with the interstate nature of the wire communication in this case. It is a sufficiency challenge, meaning that we view the evidence in the light most favorable to the government. And there are 3 pockets of evidence that I want to point to here. There's the testimony, there's the chart in Exhibit 120, and then there is the cover letter. The cover letter is properly before this court in terms of a sufficiency challenge. It was admitted, this is at Appendix 956, it was admitted without objection, without any sort of limiting instructions. And in a sufficiency challenge, this court does consider all evidence that is admitted at trial, whether or not it was properly admitted or erroneously admitted. A couple of cites for that, McDaniel v. Brown from the Supreme Court, 558 U.S. 120 at 130 to 131. And then this court's decision in United States v. Moore, 651 F. 3rd 30 at 84. And so I think the cover letter alone kind of forecloses this challenge. The cover letter says these are the physical locations of the servers that process the transaction.
That's a 951, you said?
It's at A956 where, oh, sorry, the cover letter is at A3602.
Oh,
Council did submit a couple of weeks ago a cleaner copy of this exhibit to the clerk's office, so we can submit that again if the court does not have it, because the copy in the appendix is a little bit unclear, but the cover letter is certainly legible here. And so the fact that the servers that process the transactions were located, we can see at A3605, the chart in Minnesota, that establishes on its own an interstate wire transfer. And the confrontation type issues are not properly presented here. They were not objected to. There were not limitations on the admission below. Even if we were to set aside the cover letter, we do agree that in context, the full exchange between the special agent's testimony and the chart that's admitted as part of that testimony together, viewing the evidence in the light most favorable to the government showed.
Take Mr. Berman to be saying that if this is being admitted for the truth of the matter that's bolded in the letter, then there's a confrontation clause problem with letting that in without, I guess, defendant being able to cross-examine Mr. Lindquist?
So I guess whether or not there's a confrontation issue with that, it is before this court in a sufficiency challenge. So for a sufficiency challenge, that doesn't matter whether there's a confrontation issue. Of course, the defendant didn't raise a confrontation objection below or on appeal. That's not coming out until the reply brief. But what this court and the Supreme Court have said is when you're looking at a sufficiency challenge, you look at all the evidence that is before the jury, whether it should have been admitted or not.
right. So, I mean, the way you view that conceptually is it's a historical fact about the world that this document was before the jury.
Correct.
So the jury, it's a historical possibility based on this historical fact that the jury could have taken account of this. And when we're looking at it on appeal, we're not supposed to scrutinize whether there could have been an objection made that would have prevented that evidence from coming before the jury.
Exactly. And there's good reason for that, which is that the government relies on the evidence that's admitted, even though it may always have alternative forms of evidence that it could otherwise submit. And so the government here admitted this evidence, maybe should have asked another follow-up question. Had there been an objection to this evidence? Had this evidence been excluded? Those sorts of, certainly everyone seems to acknowledge in terms of what is true in the world, there was an interstate wire transfer here. And so the government could have offered alternative proof of that, or could have put on the custodian if necessary to establish that. In this case, the government, because there wasn't an objection below, because that fully came in, that was before the trial court, and the government was permitted to rely on that in terms of establishing the interstate nature of the wire transfer.
I think I interrupted you when you said you had 3 points you wanted to make, and I gather this was one.
Sure. And then I think the other is that the testimony, so even if we were setting aside the cover letter alone is sufficient, but even if we were setting aside the cover letter, we think the exhibit in conjunction with the testimony also would independently establish that. I do think on Appendix 1148, that exchange with the agent, the question is, Special Agent Reese, did you determine whether this bank branch in Washington, D.C. communicated with computers anywhere else in the country to process these withdrawals? The answer is yes. And you can understand that yes, either as yes, I made that determination, or as yes, it did. It's ambiguous, but viewing the evidence in the light most favorable to the government, a reasonable fact finder could infer that what the agent meant was yes, it did, especially in conjunction with the chart that's in Government Exhibit 120 that's admitted immediately after that, where the agent walks through and in particular notes that the server was in Minnesota.
I have a question about, if you're done with that.
Sure,
I have a question about the tax fraud.
of course.
You argue that Scott's underreporting of income in her 2013 tax return was willful because although she reported more income than her annual salary from Park Southern, she failed to report her illegal income from her embezzlement. And I guess my question is the underreporting actually properly characterized as willful if this defendant honestly believed that there was no legal obligation to report illegally gained income? I mean, there's something kind of counterintuitive about that unless you followed the fate of Al Capone and others.
Sure. So I think there's a cleaner way to address the 2013 income, which is that this is again a sufficiency challenge. So her permissible annual salary was $60,000 in that year. She reported slightly over that. I think 61,897. But this is on 34 to 35 in our brief, and that has the appendix sites. In fact, just the direct deposits and the checks that were written out to her totaled 68,000. So in other words, even though her stated annual salary was 60,000, just the clear payroll transactions were 68,000. And then beyond that, the total earnings were 83,000. But this was an issue that was fully aired before the jury. There's no challenge to the jury instructions as to willfulness. And so this is, I think, completely a permissible jury argument that she wasn't acting willfully. She made an honest mistake. She did testify. But in this case, the jury was also permitted to not credit that testimony and instead to find her actions to be willful.
I'm not sure that I'm following how the 68,000, 61,897, 83,000, how that goes to the willfulness point.
Well, so I think it goes to she reported to the IRS approximately 62,000 in earnings. Even if you are not looking at credit card transactions on herself, the spa weekends and whatnot, even if you're just looking at just the payroll transactions, it was in fact 68,000.
I see. So what you're saying is even if she honestly, if mistakenly, thought that her illegal gains were not subject to reporting as income, even her lawful income exceeded what she reported.
I'm not sure I would characterize it as lawful, but her kind of clear payroll transactions, the transactions that did not require any sort of looking at how she was using her credit card. I guess that is not entirely responsive to my question, which is really if she thinks what I'm doing illegally, I could get in trouble under criminal law, but surely I'm not going to get in trouble under tax law because it doesn't make any sense that people would have to report illegal. I mean, because this is a subjective test. That's all I'm asking. I think that is an argument she could have made to the jury. In fact, I think it's notable that she testified in this case and her defense on the 2013 charges was not that, but was instead that she had consulted with a tax preparer. And so she was offering a tax preparer defense based on that. There was a special jury instruction that was given on the tax preparer defense, and the jury rejected that in this case. And so these are proper jury questions in terms of a defendant's intent, a defendant's mens rea. And so these are the sorts of questions where we do have to defer to the fact finder's findings. I think it's notable that also the district court very much reached the same conclusion and characterized the defendant's defense as essentially the dog ate my homework.
And for these purposes, there's no dispute that the jury got the right instruction on how it was supposed to think through the mens rea issue.
Exactly, Your
The
Honor.
question is whether they had sufficient evidence before them to reach the conclusion that they did.
That's correct, Your Honor.
And she challenges the voluntariness of her statements with respect to the agents going over to her home.
Yes, Your Honor.
But then she lets them in. She kind of goes about, her routine at home, answers a few questions, and then eventually cuts them off. At the time that she's cutting them off, it seems to be questioning more zoned in on her, more investigatory as to her. So was there any duty for the agents at that time to then at least inform her, you have a right to counsel at this point?
Well, so the Miranda question is going to be whether, in terms of whether she is in custody, is whether a reasonable person would have felt free to terminate the interview and at that point, which is exactly what she does. And so the fact that she is herself terminating the interview at that point is an awfully strong indication that she was not in custody. Also, just going through this court's Cooper factors, all of them strongly point against custody. Maybe most importantly, the district court credited the agent's testimony that when they came in, they told her that the interview was voluntary and the defendant could end it at any time. So they gave that warning at the outset.
Right, that's my point,
to
is
her.
that you would take the position that Miranda deals with custody, not with the types of questions that might go to your criminality.
Correct. Well, so Miranda requires both. Miranda requires both the interrogation by the agents and the custody.
Correct.
And so the interrogation we are not fighting on. We're not disputing that there was evidence of interrogation in this case. We're just saying that she wasn't in custody and therefore Miranda didn't kick in. Yes.
I just have one super quick question on the computer search and the denial of suppression. You briefed 4 different, I think, grounds: no expectation of privacy, Vesta consented, there was a warrant based on probable cause, officers relied on it in good faith.
Yes.
In the district court thought that the reasonable expectation of privacy in the computers, that breaks new ground in our circuit. Do you think that's right? I mean, I guess I'm asking more broadly, selecting between all the grounds you offer, which is the one that we should rely on in your view?
Yeah, so I think the good faith is the easiest ground in this case. There's as we go through, there's no basis for questioning the probable cause finding, but certainly there's no basis once the agents in this case did secure a warrant, went to the magistrate, got approval for what they're doing. There's no basis for second guessing that, given that the Leon good faith standard, which protects the warrant from suppression after that. We do think that's the cleanest ground in this case. One other note, there's a note in our brief about a pending appeal as to the contractual dispute between the two parties pending before this court. This court did recently affirm, and therefore that's been settled against Ms. Scott.
And that's the Vesta, in the Vesta.
Yes, exactly. And that goes to the consent issue. Yes. If there are no further questions, we'd ask this court to affirm.
Thank you, counsel.
Thank you.
Mr. Berman, we'll give you 2 minutes for rebuttal.
Thank you, Aaron. Let me briefly address a couple of the points that counsel made regarding the issue that I focused on, the wire communications. Assuming for the sake of argument that the cover letter is deemed to be properly admitted and that the any confrontation clause issue is waived by its admission, I think it's important to note that the letter itself doesn't really prove very much, because it refers to, and this is at Appendix 3602, records pertaining to the physical locations of the ATMs and the servers that process the transactions. Well, this wasn't an ATM transaction in the first place. It was a paper withdrawal, and I think that the court should give, if it chooses to consider the cover letter, should choose to give that very little weight in light of the mistake that appears in Wells Fargo's own letter. Second is
When you say it was a paper withdrawal, you mean going into the bank branch?
Right. I mean, I think I gave the appendix sites earlier. They're at 2583. 2587 and 2590 are the paper withdrawal slips. Ms. Scott did things the old-fashioned way here. Second is counsel's comment concerning the colloquy with Special Agent Reese at Appendix 1148, where he characterized it as ambiguous. It seems to me that's a significant concession. I mean, if the agent's evidence is ambiguous, I would submit per se that does not constitute proof beyond a reasonable doubt. And with that, let me just close on kind of a big picture thought, which is obviously we're in a court of limited jurisdiction. Doesn't matter what court you're in Maryland, where I spent most of my career, or South Carolina or DC, AUSAs are taught from day one. You have to prove the jurisdictional elements. That's what I was taught. That's what I taught. The government doesn't call the right witnesses. That's their problem. If they ask the wrong questions, that's their problem. If the record is confusing, that's their problem. If the government doesn't meet its burden, she shouldn't be found guilty beyond a reasonable doubt, and the court should not affirm a conviction on those 3 wire fraud counts. And there is some practical significance here. If I could have just a few seconds to wrap up. There's a 2-part forfeiture in this case, and there's tax forfeiture and there's a wire fraud forfeiture. And what remains outstanding from counts 1 through 3 is $153,434.04 in wire fraud forfeiture. If the government didn't prove wire fraud beyond a reasonable doubt as to all elements, she shouldn't have to pay that forfeiture, and she shouldn't have to pay the special assessments. She's pretty much done with her sentence. Everything, if the court affirms on the other accounts, it's not going to make any difference on her sentence, but she shouldn't have to pay that forfeiture and restitution if she's not guilty of those crimes. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission. Mr. Berman, you were appointed by the court to represent the appellant in this matter, and the court thanks you for your assistance.
Thank you, Your Honor. Good day.
Case number 25-1002. Frontier Airlines, Inc. petitioner versus United States Department of Transportation. Mr. Scher for the petitioner, Mr. Brewer for the respondents, Mr. Dvorsky for the intervener.
Morning, counsel. Mr. Scher, please proceed when you're ready.
Thank you, Your Honor. Good morning, and may it please the court, Aaron Scher on behalf of petitioner Frontier Airlines. Under the plain language of the statute and regulations, which no party claims is ambiguous, Frontier is eligible for the slot exemptions made available to limited incumbents in FAA 2024, and Alaska is not. Frontier qualifies as a limited incumbent for 2 main reasons. The first is that it holds or operates fewer than 40 slots. That is the definition of a limited incumbent.
But you have Congress distinguishing with 3 categories: 0 slots, those between 1 to 39, and then 40 or more.
I would agree that Congress distinguished between 3 categories. I wouldn't agree that they distinguish it exactly that way. I think what Congress did is it has a new entrant, limited incumbent, and then non-limited incumbent. What Congress did is in only the limited incumbent definition did it exclude slot exemptions from the term slot. Now, under the negative implication doctrine, we know that the adjacent definition of new entrant, it did not mean to exclude slot exemptions from the term slot. And what that does actually is it accomplishes 3 really important and logical policy goals here. And the first is that it aligns carriers in the categories that make sense. Our reading, which is just as I explained, says that a carrier who is not new to an airport, who has already entered an airport, or in Frontier's case, has been there nonstop for 25 years, could in no way be a new entrant at the airport. Rather, it's a carrier who has been engaged in air transportation at that airport, which is how DOT has defined incumbent. It has been there in a limited capacity for 25 years, and it is therefore a limited incumbent.
So this case involves just trying to diagram all the Venn diagrams and how they interrelate.
That's
But
exactly right.
I don't think and this is, I think, meant to be not a hostile question. I don't think I follow why you expend as much energy as you do trying to make the point you just did, which is that Frontier is not a new entrant. I take it that's the point you're making, and you're saying if you look at the new entrant definition under the statute, it says does not hold a slot, but by negative implication, it's okay to say that does not hold a slot or a slot exemption is the way we should read that, because slot exemption is actually singled out for specific treatment under limited incumbent. You don't have to give it the same treatment for new entrant.
That's right.
I guess, suppose I disagree with you on that, and suppose, I know you'll resist that, but suppose I'm more persuaded that slot just means slot, and Congress made pretty clear that where it wants slot exemptions to be slots, it says so, but otherwise, littered throughout the code and the regulations is a distinction between the two. And so the new entrant carrier literally means if you don't hold a slot, you're a new entrant.
Right.
Okay, then I'm not quite sure I follow why that matters for your purposes, because even if you are a new entrant, you can still be a limited incumbent, as I understand it, because that's just what the statute says. It says that new entrants, not only can you, but the statute prescribes that every limited incumbent is a new entrant. So I'm not understanding why and you can explain to me why you care as much as you do, but I don't understand why you care as much about whether you're a new entrant, because what matters to you is whether you're a limited incumbent. And if you're a limited incumbent, you may well be a new entrant, but who cares?
So that's precisely right, Your Honor, except for that last point, and this is unfortunately one of the Venn diagram tricks of this statute, and that's that every single limited incumbent is a new entrant by virtue of the new entrant, including all limited incumbents, but not all new entrants are limited incumbents.
Sure, that I understand that too, but why does that require you to say that you're not a new entrant? Because why can't you be a limited incumbent and a new entrant? But
I
then
understand.
there still could be other new entrants who are not limited incumbents. It's just that they don't include you. And you have an example of one in your reply brief, which is a brand new airline.
Right.
Or you could come, or under the regulations, as I understand it, if you're an airline who only has international slots.
Right.
There are other carriers, doesn't have to be you, but there could be other carriers who are new entrants, but are not limited incumbents, even if you're both a limited incumbent and a new entrant.
Right. I understand the question better. I'm sorry about that. I think you're exactly right. I think there is a way to read the statute where a carrier could independently qualify as a new entrant and as a limited incumbent, which according to the reading you just put forth, that would be Frontier in this case. And if that were so, then Frontier would be eligible for the slot exemptions made available in FAA 2024. The reason we put forth our reading is what it does is it makes sure that carriers qualify for only one of the categories, right? It doesn't add an overlap to the statute that Congress.
Why are you trying to do that? This is, and I know we'll hear from all counsel about this, but just speaking for myself, I don't understand the moral imperative to do that, because the statute already says on its face that there's an overlap.
Agreed.
So we already know that they're not mutually exclusive categories. We already know that there's an overlap, and we're only talking about the extent of the overlap.
Right.
And for your purposes, it seems like you could. Now, I'm not saying you necessarily win on this, but I'm just saying conceptually, it could be the case that you give up on your argument that you're not a new entrant, and you just say, well, actually, fine, I'm a new entrant, but I'm also a limited incumbent, and my argument doesn't mean that there's no such thing as a new entrant who's not a limited incumbent, because there are new entrants who are not limited incumbents. I'm just not one of them.
I think that's right, Your Honor. And what that does, what that reading does, is it naturally categorizes the carriers as Congress, the statute, the regulation intended, which is to put new entrants and limited incumbents on one side to say these are the carriers that we are prioritizing, that we are giving favor to when we are trying to bring them into these airports, because these are the carriers that are going to add the competition, they're going to add the options, they're going to reduce airfare. And so it makes sense, even as the new entrant definition says, hey, we should consider them together. As Your Honor says, sometimes, you could independently qualify as both. It would make sense for that to happen, right? Because we consider those carriers as the priority carriers. Whereas on the other hand,
Which carriers are the priority carriers?
the new entrants and the limited incumbents, because
Okay.
those are the ones that are going to accomplish the regulations and the statute goals, more competition, more options, reduced fares. Whereas on the other side, it puts non-limited incumbents.
So in that view, how is it that Frontier meets the definition of a limited incumbent air carrier?
Right.
Because it's not enough to have 0 slots, because every new entrant has 0 slots, and your argument is that assuming that Frontier is a new entrant, that it also qualifies.
Right, because Frontier, as DOT itself recognized, is a carrier that is engaged in air transportation at DCA. It is an incumbent, right? And so therefore, it must be a type of incumbent that's recognized by the statute. And there are only two. You're either a limited incumbent or you're a non-limited incumbent. And because Frontier operates and holds fewer than 40 slots at DCA, it must be a limited incumbent.
Now, that argument can't take you home if you buy what both DOT and Alaska say, which is that the best way to read the limited incumbent provisions, both the statute and the incorporated regulation, is that they mean fewer than 40, but at least one. Then you can't. Now, there's a debate about whether that's the best way to read it. But I think you have to concede that if that's the best way to read it, then even if we give you the benefit of the doubt on everything else, then you can't win.
So not precisely, Your Honor. I mean, I think that's right. I think we could not qualify as a limited incumbent there. Then we go back to the issue that we believe that slot exemptions are, by negative implication and by the express direction, that we only exclude them from such sections that are within the limited incumbent category, that we can't be a new entrant. And that puts
I
us,
see. At that point, it becomes relevant because then you say you have to be something.
have to be something.
Yeah. Okay. I see.
Right.
I see that. Okay. Go ahead.
And I'll just say, because that's an argument that was raised by Alaska. I see them past my time. So that it's actually okay for Frontier to be nothing, right? It's okay for them not to qualify as a new entrant because, okay, conceding that slot exemptions are included there. But they also shouldn't qualify as a limited incumbent because fewer than 40 actually means between 1 and 39. It is hard to imagine a reading that is more inconsistent with the statute and its purpose, because that would only apply to carriers that only operate through slot exemptions. And what it would mean is that every time a new entrant got its first 2 slot exemptions, it would immediately fall into that definitional purgatory, never be eligible for another slot or slot exemption again because they don't qualify as anything. Those are precisely the types of carriers that Congress, the DOT are trying to prioritize when they're giving access. And on the other hand, that would leave us only with non-limited incumbents, precisely carriers we are trying to move away from.
Can I ask one question about that?
Go ahead.
And this is about why is it that the definition of limited incumbent carriers specifically provides that slot exemptions don't count slots? And I guess I could imagine one hypothetical in which that comes into sharp relief, which is suppose you're an air carrier that has 35 slots and 10 slot exemptions.
Mhm.
So if you count the slot exemptions, you go to 45 and you become non-limited. If you don't count them, you're at 35 and you stay limited.
That's right.
So one way to understand the purpose of carving out slot exemptions from slots is to say, we want to make sure that that kind of air carrier isn't unfairly treated as a unlimited carrier, but they get to stay as a limited carrier on the assumption that that carrier would rather be a limited carrier than a non-limited carrier. That's a possibility. Yeah. And maybe that's the way, but there might be something else, but I'm just a little confused because the purpose, the effect of having slot exemptions count as slots is then you're more likely to be deemed an unlimited carrier than a limited one.
That's right.
And why is it that slot exemptions are excluded from slots to make sure that a carrier is not treated as an unlimited carrier rather than a limited?
Sure. So I'll say the legislative history is not altogether clear on this, but what it does accomplish, it accomplishes 3 things, and I'll take your point first. is it makes traditional slots that line of demarcation between limited incumbents and non-limited incumbents. Again, between the incumbents or the carriers that we are trying to prioritize and the carriers that we're not trying to prioritize. And that makes intuitive sense with how the statute's framed, because you're saying if you have a significant number of traditional slots, that necessarily means that you are one of these legacy carriers that has had traditional access to the airport. And we're trying to move away from you when we're granting new slots and slot exemptions. Whereas if you are a carrier with a significant number of only slot exemptions, well, then you almost by necessity are one of these carriers who is adding more options, adding more competition, reducing airfare. You are newer to the airport, and those are the carriers we are trying to favor. So the amendment in 2012 that said we exclude it only from that category, that's the main thing that it accomplished there. The two other things I'll say briefly before I sit down, it also puts the carriers into categories that align with common sense and reality. This goes back to if you do include slot exemptions with new entrant, exclude it from limited incumbent. Carrier like Frontier, who's been at an airport for 25 years, is not new. It has already entered. Right? This amendment makes sure that carriers who are actually new, have not yet entered, are new entrants. Carriers who are engaged in air transportation in a limited capacity beneath the threshold set by Congress are limited incumbents.
But as I understand it, that explanation doesn't work if one were to think that you are a limited incumbent, but you're also a new entrant.
I think that's right. Yeah, precisely. Right?
That explanation you just gave, I get it if you're treating them as mutually exclusive, so that it would mean that you're not, you would say, we shouldn't be treated as a new entrant. That doesn't make any sense. But if the way I read the statute, or a possible reading of the statute, and I'm sure we'll get an explanation about why this is not a possible reading of the statute, but a possible reading of the statute is you're both. In fact, you are a new entrant. And this whole argument you're just making about how we shouldn't be deemed a new entrant when we're already here, that falls out because whether you want to or not, you're a new entrant.
I think that's right. You know, taking your honor's point there, and then so I think then the main policy goals is using traditional slots then as a way to demarcate carriers we're trying to prioritize who have not had historic traditional slots and the carriers that we're not trying to prioritize because they have historically
then
had
it
a
goes
lot.
back to the 35-10 hypo. So you would say if you have 35 slots and you have 10 slot exemptions, the way you think about it is we still want to treat you as not, you know, a powerhouse. You're not a United.
Yes. You are a carrier who is bringing new options, new competition, downward pressure on fares.
Because even though you have 35 slots, you're still not, you don't have 100.
Right. I mean,
so you might get over the hump with the slot exemptions, but the slot exemptions really are indicative of the kind of carrier you want to protect because they're introducing competition, even if you're a 35-10, and so you're pretty close.
precisely,
That's the way you think about it.
precisely.
Well, in 2012, DOT characterized Frontier as a limited incumbent carrier. Has there been any recharacterization of that since then?
No, there hasn't, Your Honor. It did that twice, and Frontier brought that up in the proceedings, and DOT just simply ignored it. Now, not quite sure what level of deference we give to that in the Loper-Bright universe, but certainly still, the agency's decision-making must be reasoned decision-making, and part of that is addressing when like situations, when it wants to come out differently. It came out exactly the opposite, and it did not address those decisions at all. There's no further questions.
Additional questions for you at this time, and we'll give you a little time for your rebuttal.
Thank you.
Hear from the government now. Brewer.
Thank you, Your Honor. May it please the court, Simon Brewer on behalf of the Department of Transportation. The department correctly disqualified Frontier's application because it qualifies only as a new entrant air carrier at Washington National Airport. That follows from the plain statutory language that, as Judge Child's question suggests, distinguishes between carriers with 0 slots who are new entrants, carriers with 1 to 39 slots who are limited incumbents, and carriers with 40 or more slots who are non-limited incumbent carriers. Because it is uncontested that Frontier has 0 slots at Washington National Airport, it qualifies only in the first category and was therefore ineligible for the slot exemptions at issue.
I'm not sure that's necessarily the case. I mean, if we just read the plain text of the statute, 4171(4)(h)(4) treats slot exemptions as slots. So if that's the case, then why would Congress have wanted to treat an airline that operated potentially many flights at DCA under slot exemptions as a new entrant.
Let me start with the definition, Your Honor, and then we can sort of broaden out from there. So as an initial matter, I don't think we can read that definition as defining slots to include slot exemptions. I think as, first point, it would be exceedingly odd for a defined term to also include what is in the very name, an exception to that defined term. And so I think instead what Congress was doing here was incorporating the regulatory definition of slot, which is the underlying regulatory regime on which the statutory language is built. I also think that reading the definition of slot to incorporate slot exemptions makes a hash of the rest of the statute. As the Chief Judge's question to my friend on the other side suggested, there are many places in the code that distinguish between slots and slot exemptions and use those terms in the same sentence. And if the definition of slot by itself included slot exemptions already, it would be very difficult to understand why Congress felt the need to say slot and slot exemption in tandem elsewhere, for example, in section 41.714K. And then finally,
4171(4K) is just the one that disqualifies carriers with code share agreements
correct.
from qualifying for slot exemptions as limited incumbents. So it's about qualifying for them, not about what you hold. It doesn't require. So I guess, I mean, if you go back to the definition in H4, it says the term slot means a reservation for an instrument, flight, rule, takeoff, or landing by an air carrier of an aircraft in air transportation. Now, a reservation for an instrument, flight, rule, takeoff, or landing by an air carrier of an aircraft in air transportation also describes a slot exemption, does it not? Just a functional entitlement.
It functions similarly, and yes, that it allows takeoffs and landings at the airport. But again, I think the last thing that I want to mention here is I think the statutory history is very helpful. So again, this definition very closely mirrors the underlying regulatory definition on which Congress was layering the slot exemption regime. So if you look at 14 CFR section 93.213A2, that's where the definition of slot originates, and Congress was taking that language and importing it into the statute. But I think also, again, if Congress had intended to define slot to include slot exemption in that definition, it would be very difficult to understand the 2000 amendments, which added the limited incumbent definition and said, for purposes of that definition, slot shall include slot exemption. Again, that language would be entirely redundant, superfluous, if the definition of slot already included slot exemption.
But wasn't it the case that before 2000, it was generally understood that slot exemptions were not treated as slots, and that changed not sure when that changed, by negative implication.
So let me address that. So I think that's right. Before 2000, it was generally understood that slots did not include slot exemptions. And I think that makes sense of the statutory and regulatory definition of slot. From 2000 to 2012, Congress enacted a special exception, a deviation from that background understanding, and said, for purposes of the limited incumbent definition, slot will include slot exemption. So that was an exception to the background rule. In 2012, Congress decided to eliminate that exception to the background rule and provided that even for the limited incumbent definition, slot would not include slot exemption. So that returned the statutory playing field to the way it existed before. Slots and slot exemptions would be treated as distinct categories under the statutory regime. And that's the world that we live in today. And
So I think, so let's just suppose, at least, and I don't want to stop the line of questioning if there's a follow-up.
Go for it.
But so let's suppose then that, for argument's sake, that we accept your reading that slot and slot exemption are different.
Mhm.
And that even for this definition, you could just say, well, yeah, functionally, actually, the term slot, the way it's described actually covers the slot exemption. But the one thing we know is that it can't be a slot exemption because the statute draws a distinction. So we just read the definition to say the slot means a reservation for a rule or for a flight rule takeoff or landing, except by virtue of a slot exemption.
Mhm.
Because we just know that the statute draws a distinction, so it has to carve that out. So let's suppose I'm with you on that. But why does that necessarily mean you're home? Because I still don't understand. That just means that Frontier is a new entrant.
right,
But they
correct.
can be both a new entrant and a limited incumbent.
No.
Why
So
not?
Congress defined only a very particular overlap between those categories. And again, I think it's helpful to understand that this is building on the prior regulatory regime, which defined these categories.
Well, I get that they defined a particular overlap, but then it just depends on what you start with, because if they're a limited incumbent, they're definitely a new entrant,
Correct.
right?
Mhm.
So if I conclude the slot, the point that slot exemptions aren't slots matters for understanding whether somebody is a new entrant, other than by virtue of being a limited incumbent. Because
Right.
there's two ways you can be a new entrant. One is you're a limited incumbent, and therefore you're necessarily a new entrant. The other is you're a new entrant because you're an air carrier that doesn't hold slots.
Correct. And so I think the problem with reading them to be brought to have a greater overlap is that it extends the overlap that Congress enacted. So Congress set up these three categories and it said in one particular circumstance, we'll allow overlap, which is that someone who qualifies as a limited incumbent will also be permitted to be treated as a new entrant air carrier. But otherwise, that these are conceptually distinct categories, and allowing the definitions to be read in a way that creates broader overlap frustrates Congress's intent that that one particular circumstance be the one where there is an overlap in these definitional categories.
That seems, I don't understand why we have to do it that way. For one thing, if you start with whether they're a limited incumbent and you conclude that they are, so just say, I'm not even thinking about whether they're a new entrant. I'm just not looking at that part of the statute right now. I'm just going to start with the question that matters the most, whether they're a limited incumbent. I'm just looking at that provision, and let's just suppose I say, oh, they kind of, okay, I think they might qualify as limited. I mean, you yourself think they're incumbent. And then when I look to see whether they're a limited incumbent, I look to see and I say, well, they have fewer than 40 slots. So they qualify. And I know you think, well, fewer than 40 slots means actually at least one. But let's just suppose I disagree with you on that. Let's suppose I think actually, I mean, maybe not. I think different statutes and different regulations, I think both readings are plausible. If I ask, was your blood alcohol content less than 1.15, I think someone who has a 0 qualifies. You don't have to have a blood alcohol content in order to ask whether your content was less than 0.15. It's 0 is good, actually. So I think that one is a wash. So I think, yeah, Frontier could be a limited incumbent. And then by virtue of that, it's, well, no, but if we do that, then they're also a new entrant. And I think, okay, that doesn't matter because the statute already tells me they're a new entrant because they're a limited incumbent. So then I'm not even expanding, even if I bought your idea that it can only go so far. If I start with whether they're a limited incumbent and I think they qualify, then it doesn't matter that they're also a new entrant because the statute compels that.
But then there would be very little left of the new entrant definition in that world, because all carriers that have 0 slots would be limited incumbents, and then by that chain of logic.
No, not all carriers, because you have to be an incumbent.
So again, I think that's, we did use the term incumbent to say currently providing air transportation services at National Airport, but that's because that term standing alone was undefined. So the currently providing transportation at air services is not something my friend on the other side draws from the statutory or regulatory definition, right? The statutory or regulatory definition is defined purely in terms of the number of slots held at the airport, subject to the various carve-outs in the statute and
You're
the
saying the
regulation.
definition of incumbent?
Right. So the definition of incumbent that the agency used, that was drawn from the plain language of the statute for that undefined term, incumbent air carrier.
So let me ask you this. Suppose you have a carrier that has no slots or slot exemption at DCA. Okay, are they a limited incumbent carrier?
No, they're clearly be a new
Clearly
entrant.
not, right?
Yeah.
So they can't be a new entrant by virtue of being a limited incumbent carrier because they're not a limited incumbent carrier.
Correct.
Right.
Yes.
Are they a new entrant?
Yes, they'd be a
Yeah,
new
of course.
entrant.
So there's the example of a carrier who is a new entrant, but is not a limited incumbent, even if Frontier is both a limited incumbent and a new entrant.
Yes, but again, I think this is merging the categories very closely together. And when Congress has only provided for a very small overlap in those categories.
Well, I don't understand why it's merging them very closely together, because I've just given you a category, unless I'm missing something. I've just given you a category of carriers. Who I think imagine there's at least several carriers who are new entrants, but are not limited incumbents.
So maybe I can take a slightly different tack. I think that the world that Your Honor is positing is the world that existed between 2000 and 2012, when Congress decided to count slot exemptions towards the limited incumbent status. And so maybe a different way of getting to that question is, if that's what Congress had intended, it could have left in place the regulatory regime that existed from 2000 to 2012. In that world, Frontier's slot exemptions counted as slots and counted towards its limited incumbency status during that period of time.
I'm not basing it on the slot. I don't even think that the DOT, when they say that Frontier is an incumbent, it's true that they have a physical presence at the airport because of their slot exemptions, but that it just happens to be because of the slot exemption. The question is whether they're incumbent, and the point is they are because they're there. And so, yes, they count as an incumbent, and therefore the question is, are they a limited incumbent? Do they have fewer than 40 or they have more than 40? We don't count the slot exemptions to decide that, because if they had 41 slot exemptions, they would still be limited, even though they're over 40.
So I guess I disagree with the premise of the question insofar as being an incumbent carrier leaves only two possibilities, that there be a limited incumbent or a non-limited incumbent. Those are separate terms that Congress used in the statute. And if incumbent carrier only carried those two possibilities, then the statute would incorporate two entirely redundant qualification criteria. So when Congress,
Why is that? I don't understand.
So when Congress set out the eligibility in terms of an incumbent air carrier qualifying for status as a limited incumbent air carrier, if Frontier were correct and the only possibility were limited incumbent or non-limited incumbent, there would be no reason to include that first phrase at all, incumbent carrier qualifying for status as. It would be sufficient, it would achieve exactly the same result to just say, these are reserved for a limited incumbent air carrier. And that's why DOT read the statute to include two separate qualification criteria for these slot exemptions at issue.
But why? First of all, you could be an incumbent carrier who's not a limited incumbent carrier because you're an unlimited incumbent carrier.
And there was a separate set of 8 slot exemptions allocated for that category of people that also included that same particular phrase.
But then it just, that seems like, I mean, I get your point as a matter of geometry, but boy, that's taking the kind of surplusage thing to an incredible degree to say Congress was so punctilious that every situation they made sure that there was never any overlap. I mean, it just seems to me that what they could have been saying is there's two types of incumbent carriers. There are those who are limited and those who are unlimited. For those incumbent carriers who are unlimited, there are 8 slot exemptions available. For those incumbent carriers who are limited, there are 2 slot exemptions available.
But then there would be no reason to include that language. It would have achieved exactly the same effect if Congress had omitted those words. And so I think that's
but the only words you're talking about omitting is to say those incumbent carriers who are limited.
I don't.
They could just, you're saying if they had just said limited incumbent carriers get 2 slots and non-limited incumbent carriers get 8, that would be one thing. And then what I'm saying would hold. And if I'm understanding correctly, what you're saying is, but wait, they didn't just say limited incumbent carriers get 2 and non-limited get 8. They said incumbent carriers who are limited incumbent carriers get 2 and incumbent carriers who are non-limited incumbent carriers get 8. You're drawing a great deal of significance into the fact that they would have added the first part of that, right? Am I understanding it right?
That's right. I think there is significance that they added the first part of that. Again, I think Congress could have achieved that effect if it had wanted to simply by omitting that language. And we disfavor statutory interpretations that would render it surplusage.
Is that then where we wind up? Because this is very helpful because then at least it's isolating the government's understanding of why the conceptual possibility that I'm outlining can't be right. If I don't agree with you, hypothetically, if I don't agree with you that fewer than 40 means somewhere between 1 and 40, and I think 0 can count as fewer than 40. And I think somebody like Frontier therefore someone like Frontier can be a limited incumbent because they're an incumbent, because they have a presence, by your own argument. They have fewer than 40, i.e. 0 of the things that matter. So they can be limited incumbent. And the fact that they're also a new entrant doesn't matter because the statute specifically accounts for that possibility. The one thing that stands in the way of that understanding is your point about the fact that Congress in the 24 Act added the words incumbent carriers who are limited.
So yes, I think that's an important part of the argument. And I think that is consistent with how the agency read the statute in its decision. I do want to push back on the idea that, someone with 0 is qualifying as fewer than 40. And as we said, that's certainly in some contexts a permissible linguistic interpretation, no doubt about that. And the blood alcohol content example you gave might well be one of them. But that makes significantly less sense when there is a category, a separate category that is more naturally suited by its own terms to someone with zero of the relevant qualities. And here, that's the new entrant category. And so
You can be, I'm not sure this is relevant at this exact moment, but it struck me as sort of unusual that you can actually be a limited incumbent air carrier if you don't currently have any slots, if you've had them in the past. Is that right?
that you cannot be a limited
You
incumbent?
can be.
Yes, you can be a limited incumbent air
You don't
carrier
have
if you have
to be.
given up your slots in the past. Correct.
So you don't actually currently have anything.
Correct. That's exactly right.
You have follow,
No.
I actually have a follow-up on that.
Yeah,
So that's getting to, in some ways, to the spirit, the question about spirit.
Correct.
Now, I don't want to slip past the well-taken arguments that both you and Alaska have made that we shouldn't think about the spirit arguments because spirit could have intervened at a particular time and they didn't. I understand those arguments.
Mhm.
But just to get to the merits of it, for purposes of understanding holistically how the agency is thinking about the statute and the regulations. As Judge Pillard said, you can be a limited incumbent carrier even if you don't currently have any slots, because you could have been someone under the regulations who gave up your slot in pick your year way back when, right?
Correct.
You transferred it.
Yes.
And under the regulation itself, it says you're still a limited incumbent carrier
Correct.
in that situation. As I understand the agency's reasoning, someone in that position still might not be an incumbent carrier.
That's exactly right.
And that, I have to say, I'm not quite sure I follow that, because if the statute and regulations treat you as a limited incumbent carrier, how can you be a limited incumbent carrier but not an incumbent carrier?
Again, I think that returns to the agency's understanding that Congress set forth two separate eligibility criteria. And in doing so, Congress used the incumbent in two slightly different ways. So on the first criterion, it
You
used
use the same word in slightly different ways right next to each other.
Yes, and I don't think that's surprising, because in one of them, Congress was using a defined term. And so it was
When they said incumbent carrier who is a limited incumbent carrier, we're supposed to understand that they meant the word incumbent to mean two different things when they said them right next to each other.
yeah, so I think it used the term incumbent air carrier, which is an undefined term, and therefore under well-established statutory interpretation principles, the agency gave that its plain language meaning, which is someone who currently occupies the specified office, here providing air transportation at the airport. And then it used a defined term, limited incumbent air carrier. And defined terms can incorporate exceptions. They certainly do here under the well-tread regulatory and statutory definition. And so the fact that Congress has chosen to not count some kinds of holdings under those definitions, and in doing so provided for a very particular definition of limited incumbent air carrier, I don't think it's terribly surprising that
Boy, I mean, there's a lot of challenging Venn diagram issues in this case.
Yes.
One of them that doesn't seem completely challenging is the notion that there's a broader category of incumbent carrier, of which limited incumbent carrier, even by the very title of it, is a subset.
Again, I think
You
Congress,
think that that's not right?
yeah, Congress could have certainly defined it in that way. It didn't add a defined term of incumbent air carrier. That's not a term of art that has been used in the statute or the regulation previously. And so I think the agency did what it's supposed to do when it's confronted with an undefined statutory term, which is give it its plain language meaning.
And
But the
so
way-
going back to that, okay. My original question was these three categories.
Yes.
Zero, the limited incumbent from 1 to 39, and then the non-limited incumbent from 40 or more. So that's making three distinctive categories. But then you go back to all of the questioning that's been going on, where it could mean that Frontier still could be a new entrant and still be a limited incumbent. Are you taking the position that for purposes here, we need to fit within one of the categories and kind of put aside that you can be both, because you do have limited incumbent and new entrants as zero slots separated here?
Our argument is that Frontier qualifies only as a new entrant and does not meet the definition of a limited incumbent air carrier, and therefore doesn't fall into that narrowly defined overlap that Congress has permitted.
Despite that the 2012 definition by DOT classified them.
Yeah, so I'd be happy to talk about the two 2012 decisions if that would be helpful. So the first one, the May 2012 decision, simply does not characterize Frontier as a limited incumbent air carrier. That's not correct. The agency reiterated Frontier's self-characterization as a limited incumbent air carrier, but in the analysis portion of that decision, it did not accept nor reject, but did not accept that characterization. The July 2012 decision does suggest that Frontier is a limited incumbent air carrier. I think that decision needs to be understood in its context where, again, Frontier had made that assertion to the agency and no party to that proceeding had challenged Frontier's self-characterization as a limited incumbent. And I think that made good sense because in the context of the 2012 proceeding, new entrants and limited incumbents were equally eligible for the slot exemptions at issue. So there was no particular reason for anyone in the proceeding nor for the agency to make any delineation between a new entrant and a limited incumbent air carrier. And in that context, I think it's almost like judicial dicta. It's not something that should be taken to bind the agency in future proceedings.
You haven't talked about code sharing at all.
Yes. We of course.
Is there something you want to jump in on?
I also have co-chairing, but there's one question that that Judge Pillard helpfully introduced that I just want to tie a bow on it and then we'll co-chairing, if that's okay. So on this, I'll just call it the spirit set of issues, even though I take the point that it may be inappropriate to address some of these if spirit isn't appropriately in the case. You made the point in wrapping up a previous answer that we should allow Congress to give we should assume that Congress just wanted to give an ordinary meaning to incumbent. And so it just wasn't thinking about the stylized situation in which someone's treated as a limited incumbent, even though they have no ongoing physical presence because they sold off, because they transferred the slot.
Right.
I take that point, but usually, the government's in here all the time making the argument that when we're construing statutes, we take into account the regulatory backdrop and the statutory backdrop. And if you do that, then you're hit in the face with a regulation that says carrier is a limited incumbent, even though they have no physical presence at the airport. That's indisputable, correct?
Yes, that is definitely a possibility.
That's I think it's compelled when you have a carrier who had a slot that's been transferred. That carrier, by dint of the regulation, is definitely a limited incumbent.
Yes, that qualifies as the limited incumbent.
Yeah, so they qualify as a limited incumbent. So Congress would have written the term incumbent carrier in the statute, knowing that such a carrier under the then existing regulatory backdrop is a limited incumbent carrier, but would still have thought that they're still not an incumbent carrier.
Yes, and I think, again, the reason for that is because Congress set forth two eligibility criteria. It incorporated the limited incumbent definition into the second one, and to give the first one some kind of non-redundant meaning, the agency had to imbue it with some kind of independent significance. And the way it does that is by, again, treating this as an undefined term in the statute that it's going to accord the ordinary.
So your view is that because of the way the statute is phrased, and I don't remember the exact wording of 2024, but the wording that says, just so we're on exactly the same wavelength.
Yes, so Congress made the slot exemptions available to, quote, incumbent air carriers qualifying for status as a limited incumbent air carrier.
Yeah. So based on that formulation, we should conclude that that Congress must have wanted there to be incumbent air carriers who are not. No, they must have wanted for there to be limited incumbent carriers who are not incumbent carriers.
That's right. So those are two separate criteria. And again, I don't think that's terrible.
You have to admit that that's quite, unless I'm missing something, that seems like quite a conclusion that Congress had to have thought that a limited incumbent is not an incumbent.
I think it thought some limited incumbents would not necessarily meet the common English understanding of incumbent. Yeah, so
in other words, even though you're a limited incumbent, even though, suppose I change limited incumbent, it seems to me to be a fair translation of limited incumbent to say incumbent who's limited.
yes, I guess I don't see any significant, it could have chosen different words to define.
So if that's true, then the argument would be an incumbent who's limited is not an incumbent.
I think this happens when there's defined terms that include exceptions, and
that is
deviations.
Right? Am I right that would be the consequence? That if you think it's okay to treat a limited incumbent as an incumbent who's limited, you'd also think that means that an incumbent who's limited is not an
So
exchange.
I guess I would say, again, Congress chose particular words here. It chose to use a defined term under the statute, and it chose to use a non-defined term. The one other point I'd like to make is this is not a new formulation. So if you look at 718G3, for example, Congress has used this incumbent air carriers qualifying for status as language before. And I think, again, if you thought that these were entirely redundant terms, it would be passing strange that Congress has repeatedly over the years chosen this formulation that, again, in Frontier's view, in Spirit's view, sort of collapses the two into one phrase that could be shortened with no change in the meaning of the statute.
But I'm sorry.
Wait, come again. Can you explain what you just said?
Yes. So Congress has repeatedly used this phrase of incumbent carrier qualifying for status as. And if that were truly meaningless language, it adds nothing to the statute. It just means that, again, an air carrier has to be a limited incumbent. And we could delete those words from the statute with no effect on the statute's meaning. It would be exceedingly strange that Congress has repeatedly used that language over the years to define the eligibility criteria for these slot
So you're saying
exemptions.
that the going to the trouble of saying an incumbent carrier qualified for status as a limited incumbent air carrier, and this is central to your argument, carries the negative implication that there are limited incumbent air carriers who are not at all incumbent, other than the category who are limited incumbent air carriers because they once held and don't currently hold slots?
Right. So the category would be
Beyond that, in your view.
So yeah, it would be carriers that do not currently operate at the airport, that are not providing air transportation
That is
services.
the only non-incumbent subset that you're relying on of limited incumbent air carrier, or that is one, but you're also.
That's the one the agency set forth in its decision, which is,
And that's Spirit's position.
and this is contrary to Spirit's position,
This
which
is your
is
answer to Spirit's position.
exactly right. So what the agency set forth is that to be an incumbent air carrier, that undefined term under the plain meaning of those words, one must be currently providing air transportation services at the airport.
So, I know this is going to seem like it's beating a several times beaten object, but let me just make sure that I understand the implications of your argument. So I take your point that the statute says in several places, incumbent carriers qualifying for status as either non-limited or limited. Let's just use limited for now. So suppose Congress writes a statute that says those incumbent carriers qualifying for status as limited carriers shall have access to 2 slot exemptions. Those incumbent carriers qualifying for status as non-limited carriers shall have access to 8 slot exemptions.
So
Then wouldn't it work perfectly well to say, yeah, that means that every limited incumbent is a incumbent, every unlimited incumbent is an incumbent, but that's just how Congress described it.
So there's, I think, a couple of linguistic differences in the statute Your Honor just described. So for one, using those as a descriptor, right,
Yeah, I
suggests that it
added those.
relates.
I'll give you that. I
Yeah.
added those.
So I think that's one reason.
Reading a lot into adding those, but I take your point. That does add the word.
But I think that the significance there is that Congress could have chosen different language to accomplish
Okay.
that. And, again, it said it could have defined the universe of eligible carriers in different ways. And certainly, again, just to reiterate to
I
our
think it would be
basic.
the same thing if you even drop those. But anyways, I take your point that those adds emphasis to that. But then what's your second point?
And the second point is, again, we would still strive to give some independent significance to every word that Congress has used in the statute.
So in that hypothetical, you think I would still conclude that there have to be limited incumbents who are not incumbents?
Again, I would have to look at the very particular wording of the statute, but yes, I think we would start from the presumption that Congress is intentional in choosing its language.
All right, let me make sure there's no further. Okay, it's very, very helpful. Thank
Great.
you.
Thanks.
Mr. Dvoretsky.
Good morning, Your Honors. May it please the court, Shai Dvoretsky on behalf of Alaska Airlines. I've spent a lot of time with Venn diagrams myself on this case. This is not a statute like, say, ERISA, that you would describe as a comprehensive and reticulated scheme. It is hard to make the Venn diagrams work perfectly. And in part, that is a function of the nature of the statute and its history. This is a statute that came about through a series of ad hoc provisions that Congress passed when it wanted to create or to give additional slot exemptions to particular carriers. And so I think the focus here ought to be on what is the latest piece of that puzzle? What did Congress enact in 2024? And in 2024, Congress made slot exemptions available only to limited and non-limited incumbents, not to new entrants. So focusing on the question of what is a limited incumbent, because Frontier needs to be a limited incumbent in order to qualify for the slot exemptions that it wants. I think that tees up the question of whether fewer than 40 can include 0 or whether that has to mean 1 through 39. I take your point, Chief Judge Srinivasan, that in the abstract, fewer than something might include 0, it might not. Here, there are contextual and textual cues that tell us that fewer than 40 means 1 through 39. The first of those is the word incumbent. When we talk about a limited incumbent carrier, we're talking about a limited incumbent carrier as to slots. We are also talking about an operator, an airline, that holds or operates fewer than 40 slots. It would not be natural to say that you hold or operate 0 slots. If I said to you, I went to the supermarket and I came back holding fewer than 10 apples, you would be surprised if I opened my shopping bag and there were 0 apples in there. That's an unnatural way to say I came back holding fewer than 10 apples if the supermarket was sold out of apples. And so the words, and likewise, the word in.
I understand that. I guess it seems to me to depend on whether you were asked the question or whether you just volunteered it as the shopper. If you just asked the question, are you holding fewer than 10 and you had 0, I think your answer would just be yes.
If I was asked, did I come back from the supermarket holding fewer than 10 apples? My answer to that in normal English would be, I didn't find any apples at the supermarket. I wouldn't say, yes, I'm holding fewer than 10. I would feel like that was a trick way to ask me that question. Did you find any apples at the supermarket? So the words hold or operate, I think, tell us that you must hold or operate something. It's an unnatural way to say you hold or operate nothing. As to the word.
Remind me, the words hold or operate are where?
This is in 14 CFR 93-213, which is the regulatory provision that is incorporated into.
Under A5, it's the one that substitutes 40 for 12.
That's right. It's incorporated into the statutory definition in A5.
Yep. So we treat that as part of the statute, and it says that holds or operates fewer than 40. And your submission is, if you have 0, it doesn't.
You don't qualify.
You don't qualify, and it would be an unnatural way to express having 0 slots to say you hold or operate 0 slots, especially when Congress has created this separate category, this additional category for new entrants, which is expressly geared towards an air carrier that does not hold a slot, which is what Frontier is here.
So I want to make sure I understand your linguistic point. So if I ask the question to someone in Frontier's position, do you hold or operate fewer than 40 slots? You think Frontier's answer should be, and let's take as a given that they have 0 slots. So if I ask the question, do you hold or operate fewer than 40 slots? The answer should be.
We do not hold or operate any slots would be the natural way to express that.
But first, if you're answering Justice O'Connor and she says, I first have a yes or no answer, your first answer would be no, under his hypothetical, right? Do you hold or operate fewer than 40 slots? No.
Correct.
You hold or operate none.
Correct. And the additional force for that argument comes from the use of the word incumbent. We're talking about a limited incumbent carrier. The word incumbent is really serving as an adjective here. we're shorthanding it as a noun, like a congressional incumbent, but really it's being used as an adjective to describe a limited incumbent carrier. What kind of carrier is it? It's an incumbent carrier. The adjective there is serving the function of saying that the carrier occupies a particular position, or again, holds something. And so not only do we have the words holds or operate in the statute, but we have the word incumbent that is doing the same kind of work, all suggesting that fewer than 40 means that you must have something. Now, Chief Judge Srinivasan, in terms of your questions to Mr. Brewer about whether the word incumbent means different things in this same provision, it doesn't mean different things. The word incumbent, again, it's serving as an adjective. We're talking about incumbent air carriers at DCA, and we're talking about limited incumbent air carrier and limited incumbent carriers. It's giving meaning to those other terms. It is referring to those other terms. Incumbent air carrier at DCA, is this an air carrier that currently holds some position at DCA? Do you fly into or out of DCA? Limited incumbent carrier then draws in this other regulatory and statutory definition, and that's referring to incumbency with respect to slots. But the word incumbent means the same thing and is doing the same thing in both places. It's simply referring to different things, to your status flying in and out of the airport in the first part of the test that Mr. Brewer referred to, and to limited incumbency status in the second part of the test.
So, and the conclusion from that would be that even though you're a limited incumbent, you're not an incumbent.
There could be a scenario, right, where you are a limited incumbent but not an incumbent. And the other thing to point out on that, and again, this goes back to being something of an unusual ad hoc sort of statute, limited incumbent carrier is defined in a strange way because it is defined as a carrier that either has slots now or had slots at any time since, I think it was 1985, since a particular point. And so it's simply a function of how Congress has oddly chosen to define limited incumbent carrier, that you could end up in a situation with somebody who, yes, technically is a limited incumbent carrier because they had a slot that they got rid of back in 1986, but they haven't flown since then, so they are not an incumbent air carrier at DCA. And again, Congress in the test here created a two-part test, but again, to your questions earlier, Chief Judge Srinivasan, it's not a test that is anomalous because it's giving incumbent different meanings. It's incumbent simply has different reference in the two parts of the test.
But you'd have to hypothesize a Congress who understood that under the regulations. I mean, if Congress is omniscient, if they truly understood everything, I think the Congress would have spelled it out even more if your understanding and the DOT's understanding is right, and would have made clear that even though it might strike you as a little bit odd that incumbent carrier is not a broader subset that necessarily encompasses limited incumbent carrier, we're going to treat it as that for these purposes. We're going to come up with a different term, a carrier with a presence. We're just going to come up with some different, just to avoid what strikes me at first blush as a somewhat anomalous, that Congress necessarily meant to use incumbent carrier in a way that means not all limited incumbent carriers, even though the regulations say that somebody who used to have a slot and doesn't have a certain ongoing physical presence is a limited incumbent carrier.
I'm not saying Congress couldn't have done a better job.
Yeah.
This is, however.
So you're saying limited incumbent air carrier, which can include an air carrier that had slots as of 1988 or, at some point, but no longer has them.
Right.
Whereas incumbent air carrier, DCA, in your view, is an air carrier with a current presence.
Well, because it says at DCA as of the date of enactment of the FAA Reauthorization Act of 2024.
But I think
go ahead.
But I think what under the regulations, if you say, are you a limited air carrier as of 2024? The answer is yes, you are a limited air carrier as of that date.
Because you had the slots going back to 1985 or whatever.
So the date reference, I don't know how much work it does, because under the regulations, you're treated as a limited air carrier in 2024. Even though that the reason I get that it's somewhat metaphysical in that you're being treated as that by reference to your having had a slot 20 years ago. Right. No longer having.
I think that's right. Look,
You're just saying it can be read. The word incumbent as used in limited incumbent air carrier can be read to use incumbency differently from in incumbent air carrier at DCA because, in your view, in the context of the statute, incumbent in the phrase incumbent air carrier at DCA means, I think what Chief Judge Srinivasan said, current presence. it means something different. It doesn't mean the same thing as, because under LIAC, it could be someone who has no current presence as defined.
I think that's right. And I also think there is nothing anomalous or differential about the meaning of incumbent in these two instances. I think incumbent is just referring to different things, but the word incumbent itself is consistently understood. As far as the,
I'm not sure I
Go ahead.
follow that. You said that they have different reference in the two places. They're not different meaning. I'm not sure I see the fine distinction you're making.
sure,
They
well,
seem to have different meaning.
either way, what the word incumbent, looking at that in isolation, it is describing a type of air carrier. What type of air carrier is describing? It's describing an air carrier that occupies a particular position or place. That's the basic meaning of the word incumbent. Now, when we're looking at the first, when we're looking at the first part of the test, what position or place are we asking about? Well, we're asking whether it's an incumbent carrier at DCA. Is it one that flies into or out of Reagan National Airport? When we're looking at the second part of the test, limited incumbent carrier, we're asking, does it occupy a position or place as the statute defines limited incumbent carrier, which is to say, with respect to slots? That's what we get out of the CFR provision that is incorporated into H5. And
At
so
DCA.
sure. But limited incumbent carrier is defined specifically with respect to holding or operating slots. Incumbent air carrier is not a defined term within the statute, and that is best understood as simply being an air carrier that, again, using my ordinary English definition, holds or occupies a position or place flying into or out of DCA.
Now, that's
Correct.
the important thing for you. It's
Correct.
at DCA now is one meaning of incumbent, and with respect to slots ever after 1985 is the other.
Correct. Because the 1985 piece is coming in through the statutory and regulatory definition of limited incumbent. And I apologize, I'm not sure if it's 1985, but I think it's the mid-1980s.
All right, yeah, I think you might be right. You might be right.
Can I go back to where you started, which is how we understand holds or operates fewer than?
Sure.
Because I do think that everybody, as I understand the way the arguments shake out, all sides agree that if your understanding is right, then your side prevails and Frontier doesn't. Putting aside Frontier's argument that new entrant does not hold a slot means does not hold a slot or a slot exemption.
Which I disagree with, but we can put that
Yes,
aside.
yeah, and I'm just saying that for these purposes, I'm going to say we all disagree with that, even though I know Frontier doesn't want us to do that. But just for understanding, because I think everybody then agrees that then what we're down to is whether fewer than 40 means 0 or whether it means at least 1.
Right.
And I just to understand linguistically where we are. I don't think operates is just to strip it away. Let's just take out or operates, and let's just talk about holds.
Okay.
Because I think that's where it seems like the point of emphasis is. So
But I do think it's
no.
both, but I'm happy to.
okay,
focus
then
on
let's do them
holds.
separately because it's an or,
Yeah,
so we
okay.
can just do them one at a time. So an air carrier that holds 0 slots, and let's just do holds for a second, that holds 0 slots. The answer to whether that air carrier holds fewer than 40 is no. That under your,
Correct, because the answer is you do not hold fewer than 40, you hold 0. But I know we're taking these terms in isolation. I do think it's important to remember, though, that holds, operates, and incumbent are all mutually reinforcing terms that suggest that you must hold something, you must operate something, you must be an incumbent occupying a position or place as to something, and that something is slots. So we can look at each term individually,
Yeah.
but I also think that the fact that you have the three of them
Okay.
together is just triple underscoring
I take that.
that this is not the blood alcohol example for the person in the hall.
Yeah, because of the words holds, operates, and incumbent, all in your view presuppose
That you hold something, that you are an incumbent
the
as to
thing that
something.
you're asking about, slots.
Correct. And the thing that you're asking about is slots, because that's what the whole definition of A5 and the regulatory definition H5, and the regulatory definition that it incorporates is talking about. It's talking about slots, and specifically not slot exemptions, just slots.
Yeah, so if a police officer pulls over someone and asks in trying to discern whether they've been drinking, are you holding a bottle, are you holding fewer than 5 bottles of alcohol? I guess, scratch that, it's just too contrived. Okay, I think I understand the holds or operates, I think that's helpful. See if there's any-
Did you have fewer than 2 drinks? No, I had no drinks.
Right, that's one way to do it, yeah, did you have fewer than 2 drinks?
And the other point that I would make on this, and I don't want to drag us all the way into Venn diagrams, because as I started out by saying, I think there actually isn't going to be a satisfactory answer in this statute, the way there might be under ERISA or the tax code or some other provision to make everything fit perfectly together.
Yeah.
I do think that while Congress created some amount of overlap by making every limited incumbent a new entrant, it did not make, I'm sorry, but a new entrant means a new entrant or a limited incumbent.
Yep.
That doesn't mean that the overlap goes entirely the other way.
True.
And Congress has separately, in a number of places in this statute, differentiated between new entrants and limited incumbents. It did so in the 2024 Act when it made these slot exemptions available only to limited incumbents.
I think that has to be, I think there's a lot of force to that proposition that the category of new entrants who are not limited incumbents can't be 0. That, I think, that's got to be right, that there must be some new entrants who are not limited incumbents. And I think, I think that has to be right. But then Frontier could still be both a limited incumbent and a new entrant while still leaving room for some new entrants who are not limited incumbents.
I think the question is how much overlap you understand this statute to be creating. It's not going to be perfect because Congress itself already created some overlap in this hodgepodge of a statute. But as a general way of reading statutes, we try to avoid creating overlap where we can. Frontier's interpretation would create more overlap than ours would, and unnecessarily so. And that is another contextual cue, along with holds, operates, incumbents, for why you shouldn't create that overlap. Fewer than 40 should mean 1 through 39, not 0. That's my only Venn diagram. Not that it's going to be perfect, but it's just another clue along with the others for why fewer than 40 has to mean 1 at least.
Thank you, unless there are further questions. Thank you,
All right.
Mr. Dworetzky.
Thank you.
Chair will give you, we've gone on for a while, we'll give you 3 minutes for a rebuttal.
Thank you, Your Honors. I want to push back on the idea that our reading creates more of an overlap than their reading. And that's, of course, because under our reading, the new entrant definition is wholly separate from the limited incumbent definition. Now, I don't want to tread over grounds that Your Honor said where you can actually be both of those things. I think in that situation, there is more of an overlap, but under our reading, there is not. Those are wholly distinct things. Somebody who is actually new, who has not yet entered, is a new entrant. Somebody who is already engaged in air transportation at the airport, so long as there are fewer than 40 slots, they're a limited incumbent. Their reading requires that the court make at least 2 edits to the statute for Frontier's eligibility. We haven't even talked about Alaska's eligibility yet, but for Frontier's. And the first is that the court graft that slot exemption exclusion from the limited incumbent definition into the new entrant definition such that it doesn't count there. And second, that the court rewrite fewer than 40 to mean between 1 and 39 or at least 1. Again, that's not what the statute says. As we pointed out in our briefing, Congress, DOT.
Say rewrite fewer than 40, but there's not a precedent that this has been defined, that fewer than 40 is 0 or the other way. That you would define it.
Your Honor, there is not a precedent in regards to this statute. I think as we showed in our briefing though, Congress, DOT, and other agencies know very well how to define a range of numbers that excludes 0 when that's its intention. It says, uses language such as greater than 0, at least 1, between 1 and some positive number. Indeed, that's exactly how DOT And Alaska tried to rewrite the statute here, saying fewer than 40 actually means between 1 and 39. Congress and DOT knew how to use that language and chose not to here. And I would say that there is precedent. We pointed to the Gorman case out of this circuit, as well as to other cases in the Second Circuit and the Sixth Circuit that looked at it under de novo standard of review and held that a range of numbers defined by less than a positive number clearly and unambiguously includes 0.
So, based on the argument you just heard about the fact that holds or operates, especially it's reinforced by incumbent, can be seen to presuppose holding or operating or having incumbency in some measure, even if it's a small measure. Your response is, if someone were to ask Frontier, do you hold or operate fewer than 40 slots? Your thinking is the answer has to be yes, because I have 0.
Yes.
Whereas, I mean, do you not at least acknowledge that if somebody said no, because I have 0, do you not at least acknowledge that that's actually, you could understand why they would say that, because holder operates kind of seems to assume that you're holding or operating in some measure. So that's why it's prefaced by no. And then once you explain because I have 0, you see, oh, okay, well, I understand why you said no, because you don't have any.
I can acknowledge that somebody could answer it that way. Of course, the court's role now is to look at what is the single best meaning of the statute. I don't think answering no to the question of do I have fewer than 40 and I have 0, it's, well, no, I don't.
You hold.
Do you hold or operate fewer than 40? And the answer is no, I have 0. That seems like a very unnatural.
No, I don't hold or operate any.
Yeah, I don't think that's the right way to answer that question. I think the much more natural reading would be to say, yes, I hold or operate fewer than 40. If the question is posed that way, and then pushed up against the fact that slot exemptions are included in new entrant, we can't be there, have to be something. The only thing that we can be under the plain language is as a limited incumbent.
But the way you ask the question, it makes their assume that you're operating something
Right.
as opposed to having 0. So I think that's why there's a little bit of back and forth. And going to Judge Pillard's example earlier, did you have fewer than 2 drinks? A person hearing that will feel like you're making an assumption that they had a drink, and they're trying to get from under that they don't want the police officer to think they had any. So they would say, no, I had no drinks.
Right. Completely understand you. I'm careful making assumptions with what Congress is trying to think, right? The plain language is the best indication of what it's trying to think. Then we go back to the point that slot exemptions through negative implication and through the express statement that, hey, this exclusion only applies to such sections, right? The limited incumbent definition, the regulation, to other regulations that aren't relevant here. That's only excluded from limited incumbent. Therefore, it's included in the new entrant. And so making that assumption, as you just did, that would mean that Frontier is not a limited incumbent and also not a new entrant. And as we discussed, that's not appropriate. That offends what the statute's trying to get at. That also is totally contrary to how DOT always handles these situations. Right? When DOT determines somebody's eligibility, they don't say you're not a limited incumbent, see you later. They say you're not a limited incumbent because you're something else.
Well, when the question is whether you're eligible for slots for which only limited incumbent air carriers are eligible, it would make sense to just say, are you that?
It would make sense, except look at how DOT treated Frontier in this case, right? Frontier says we are a limited incumbent. We are entitled to these slots. DOT erroneously said you're not a limited incumbent because you're a new entrant. It didn't say you're not a limited incumbent. You are in Never Never Land. Good luck. It said, no, you have to be something. And again, that goes back to what the statute is really trying to get at. We are trying to bring in carriers to add competition, to add options, to add fares. And if we keep pushing carriers outside of categories, then it's not accomplishing that.
I have a much earlier question I should have asked you before, which is, if we were to determine that that Frontier is ineligible to receive slot exemptions as a limited incumbent air carrier, would you still have standing to dispute the award of the slot exemptions to Alaska?
I don't believe so, Your Honor. I think there's a way to read some of the competitive standing cases in a way that we would, but I would at least agree that Frontier has not articulated that basis in the briefing, and so
Although
it
it
would.
seemed like maybe it did that below, and I was a little surprised by that. In the motion for an emergency stay, of the department's order, I think this was in the district court, you provided an affidavit from Joshua Flyer stating that Alaska's proposed flight to San Diego would cost you $500,000 in lost revenue, but you don't rely on that here?
I mean, I think you're right, Your Honor. I think the main point that we lead with is the court has to address our eligibility first. If you find that we're eligible, nobody questions that we have standing to dispute their eligibility. I think that there absolutely is a way to read the record so that emergency motion came actually in this court, but it relied on a lot that was discussed in the agency proceedings. But I think you're absolutely right. And under whether it's disappointed bidder standing cases, whether it's competitor standing cases, you can say, yes, when you are competing against somebody in the exact same sandbox for the exact same scarce resources, a reading of a statute or regulation that expands how your competitor is able to compete, you do have standing to challenge that.
But if you're not eligible to be in the sandbox to begin with, and it's about competition between other people, then you're saying you don't have the same stake.
That's right. That's exactly right. That's how the competitor standing cases come out. And that's why I think our main argument is that we're eligible. We certainly have standing. Precisely. Happy to answer any questions on Alaska's co-chair provision if the court wants to talk about it, but I just think briefly that provision couldn't be clearer. They undisputedly have a co-chair. It undisputedly exceeds the 20 slot and slot exemption cap. They have 522 together. That facially renders them ineligible for the slot exemptions as a limited incumbent. So if there are no further questions for all the reasons stated here and in our briefs, we ask that the court allocate the slot exemptions to Frontier, who is the only carrier who is eligible. Thank you.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
This honorable court now stands adjourned until Friday, May 9th at 9:30 a.m.